Over the years, I've been asked many times by conditional permanent residents. So here I mean those with a 2-year conditional green card through marriage. If my marriage is or has fallen apart, do I lose my green card too? The good news is it's possible to keep your green card by filing an I-751 waiver showing immigration that the marriage was real, but it just didn't work out. This is often referred to as a good faith marriage waiver. Now, there are other grounds of waiver that you may also qualify for, and we covered those in another video, so the link will be below. But here, let's focus on the good faith marriage waiver, both on the procedure as well as the evidence you should have. Hi, I'm SohYoon Atac. I'm an attorney and one of the founders of Adam Law Group. We release videos about the law, including immigration. If this is of interest to you and you want to know more about how the law can serve you, please subscribe. If you're going through the demise of your marriage or have recently gone through that, I can only imagine you're having some tough times, and probably the last thing you want to do is think about immigration. But if you want to stay in the US, you have to deal with US immigration. So I applaud you for looking into this, which I know you're doing because you're watching this video. Because you need to get an understanding of the immigration requirements and start collecting evidence as soon as you can. Having worked with many people in this situation over the years, collecting documents while things are fresh in time and while you may have better access to certain documentation can be an important advantage, especially if your ex-spouse is not going to be supportive in your waiver filing. Now, that's not always the case, but given the circumstance, that is somewhat likely. Also, if you're in limbo regarding your marriage, and only you can decide about the relationship, whether to divorce or if you can repair and save the marriage, again, it makes sense to know your options so that you don't feel unnecessarily trapped or become ill-prepared. Some have had the mistaken belief, sometimes fueled by their spouse, that the only way they can keep their green card is to stay in a terrible broken marriage. While there is a risk to everything, based on the many people we've helped keep their green cards through divorce, that is simply not true. Let's talk about the immigration rules and procedures. Just the fact of whether you separate or file for a divorce or finish your divorce, those things don't just poof, make your green card disappear. You still have it, which is a good thing. However, you still do need to file the I-751 petition to remove conditions on residence. The difference here is that you'll be filing the I-751 with a request for a waiver of the joint filing requirement based on the good faith marriage. And which means that the marriage is real and you entered into it in good faith, but then unfortunately it ended. Now, in order to file the I-751 waiver under this ground, you need to have a finalized divorce decree. So you can't be in the middle of your divorce proceedings. You have to be actually completed with a finalized divorce decree from the court. Another difference here is the timing. Unlike the jointly filed I-751, which can only be filed in the 90-day period, that window before the expiration of your 2-year green card, this I-751 waiver can be filed before, during, or after that 90-day window. Now, we do recommend, though, that you don't just wait around for a long time or wait for that 90-day period to come, because it doesn't matter. And our recommendation is that as soon as the divorce is finalized, you should quickly make the filing. Now, what if you've already filed a joint I-751, meaning you filed it with your spouse together, and then your marriage ends? In this case, you need to request that the pending I-751 be adjudicated now as a waiver. Now, this requirement for a finalized, done divorce makes for a tricky situation if you are separated or in the process of getting a divorce. So if that's the case, then I highly recommend that you speak with an immigration attorney, because there are a lot of kind of procedural considerations that you want to talk through. I want to say a couple things about the divorce process. So we've seen where people in the process of getting a divorce, especially if it's like an uncontested divorce, where they kind of use like templated forms for their filings. And we've seen it where this kind of like pre-done form says something like, the couple has been separated for 2 years and now they file for divorce. What? That would not make any sense in the situation of a conditional resident, because that would mean like you've never lived together. And so I really caution you to be careful because you have immigration involved. And I would recommend that you use a divorce attorney. And if not, to be at least really, really careful and read through everything so that you're not accidentally saying something to the court that contradicts what you are telling immigration. Some people have the belief that a divorce can only be for good cause when you're a conditional resident, and that only the petitioning spouse can file for divorce in order for it to be okay with immigration. And it actually used to be this way, but since this law change in 1990, that has not been the case. So I just want to clarify that either party can file for the divorce, and you don't need any reason. It can be just like irreconcilable differences type of, the marriage is just ending. How and with what evidence do you convince immigration to grant your good faith marriage waiver and let you keep your green card? The immigration officer must believe that you entered the marriage with the intention to have a life together with your spouse. And they also look at your post-marriage conduct, so what you've done since then. So you need to show that this was not a fake or green card marriage, because the idea is that a failed marriage is okay, but not a sham marriage. The evidence time period includes prior to entering the marriage, which is like the courtship, as well as at the time of entering the marriage. However, I want to point out that we generally don't want to repeat information that was already submitted in the adjustment of status or the I-130 filing. However, if we do that for strategic reasons, we will point that out in the cover letter so that the officer is aware that that has been previously submitted. The evidence time period also includes time after the marriage. So even though this doesn't help prove one's intention when entering into the marriage, what you've done since the marriage certainly does go towards showing a good faith marriage. And we always include this because it really helps tie all the evidence together and paint a more full and persuasive picture for the officer. So I highly recommend you do that. Affidavits can also be very persuasive and powerful. So we recommend you get as many as you can from people that can attest to the marriage or what happened, and that would be really helpful. Let me give you some examples of the topics the evidence should cover. Again, the point here is to show that you had a good faith marriage. In that sense, the types of evidence you would include is not any different than what you would include in a jointly filed I-751 filing. So for a full discussion of what evidence you should include, please feel free to check out our other video on the joint I-751 filing, and there you'll see, some more information about, all the evidence that helps show a good faith marriage. You must absolutely include information about cohabitation, that you live together with your spouse. And maybe this goes without saying, but shorter the length of time that you live together with your spouse, the more problematic it is. So again, if you have an extended period region that live together, you definitely need to have good explanations. And I highly recommend you speak with an immigration attorney so that you can, get ahead in front of that and address that issue. But certainly you want to address and show that you live together. And that could be with things like, lease agreements or utility bills and things like that. Also, another big one is that you must show that you shared your finances. Here, heavier the entanglements, the better. Unfortunately, that probably means more of a headache in terms of the divorce proceedings. However, for immigration purposes, it would be helpful the more commingled and joined your finances, were. Here, combined assets are really great, especially things like home, car, or joint investments, things like that. It can also be joint liabilities, like, you were together liable on a loan and things like that. And, again, here you would have financial statements, bank statements, and things like that. And as I mentioned before, it's important to, while you have access to these things, if there's a joint account, if the divorce is finished, you may no longer have access to that account. So it makes sense to collect the evidence, as soon as you're able while you have access. Another topic, if this applies to you, is did you have kids together? Did you have any biological children, adopt any children, or were in the process to adopt children? I think that would also be really good evidence. Now, I have to include my caveat again, as I've done elsewhere, that just some people have the idea that, well, we have a child together, so there's no way our case can be denied. Newsflash, there have been cases where a couple did have biological children, and the case was still denied. So it's not a guarantee, but certainly it's excellent evidence, so you should include that information. And you can look at other things like, did you take a lot of trips together or any trip together? And that would certainly be good evidence. And anything that can document the fact that you and your ex-spouse were out in society together as a couple. So events like weddings or work parties, things like that, those are excellent. And you really want to be able to document that you're out in society. And I know, with the pandemic, there have been a lot less events like that, but whatever you can do, that'd be really helpful. And other evidence or other things, especially as immigration has called it, objective and easy to obtain documentation like emails or phone records that kind of show a life together, you should definitely, get as much of that together as you can. And decide, and from that, select what makes sense to submit as part of your package. Interestingly, things that are considered negative for the marriage or showing the marriage in a negative light can also be helpful evidence to show that the marriage was a good faith marriage. So what do I mean by this? We've used police reports, for example, in the past about regarding a domestic dispute. And of course, if there's any chance that this can be used against you, or in this case, look like you're engaging in domestic violence or anything like that, you have to be, of course, super, super careful, and because this can make you deportable. So in fact, I would seek out the advice of an attorney where you have any evidence that clearly helps show that the marriage was real, you're having fights and, things like that, but where there can be any concern that it may be used against you. Other examples of this type of evidence could be something like either messages or correspondence of a negative nature, but that show a real dispute or a fight, and that kind of shows that clearly this is a really married couple having an argument. Another example, and certainly less risky, would be evidence about having engaged in either couples therapy or counseling to help, try to repair your marriage. So that would be evidence showing that, yes, there are problems, but you're going through, couples counseling, and this was a real marriage. Especially as this may be a personally challenging time, I hope this gives you a better idea of U.S. immigration, and that with a proper I-751 waiver request based on a good faith marriage that terminated, that you have the opportunity to have the condition removed on your green card and continue your life, hopefully, and have that option to continue your life in the United States. I do particularly recommend that you at least consult with an attorney for the I-751 waiver filing. And whatever you do, I wish you the best of luck. Lastly, I'm very excited about this. We're launching SimVisa. SimVisa is a service that is a more affordable DIY option for certain immigration filings. So this is for people that are looking for an alternative to retaining an attorney or a firm like Adam Law Group. So if you or someone you know may be interested, the link will be below.